Değerli katılımcılar, ikinci oturumumuza hoş geldiniz. Birinci oturumdaki konuşmacılarımıza ve oturum başkanımıza katkılarından dolayı teşekkür ediyoruz. İkinci oturumumuzda Sayın Profesör Doktor Halil Akkanat, Sayın Profesör Doktor Murat Atalı, Sayın Profesör Doktor Burak Gemalmaz, Sayın Doçent Doktor Francesco Paolo Patti ve Sayın Doktor Zohar Efroni tebliğlerini sunacak olup oturuma Kuzey Kıbrıs Türk Cumhuriyeti Kişisel Verileri Koruma Kurulu Başkanı Sayın Hürol Meğer başkanlık edecektir. Sayın Başkanım, oturumu yönetmek üzere sözü size bırakıyorum.
Teşekkür ederim. Sayın KVKK Başkanı, Sayın Türkiye İnsan Hakları ve Eşitlik Kurumu Başkanı, Sayın Türk-Alman Üniversitesi Rektörü, Sayın İstanbul Üniversitesi Rektörü ve değerli katılımcılar, ikinci oturuma hepiniz hoş geldiniz. Az önce Büşra Hanım'ın da söylediği gibi bu oturumda Sayın Doçent Doktor Francesco Paolo Patti, Sayın Profesör Doktor Halil Akkanat, Sayın Profesör Doktor Murat Atalı, Sayın Profesör Doktor Burak Gemalmaz ve Sayın Doktor Zohar Efroni sunumlarını gerçekleştireceklerdir. İlk konuşmacımız Doçent Doktor Francesco Patti olacaktır. Mr. Patti, it is your turn and you have 20 minutes, please.
A real honor to have the possibility to speak here in this international congress. It's the second time that I do it, although in distance, with Turkey, and I am aware about the efforts of Turkey in the field of personal data, and also of the interest that Turkey has for the European regulation, which is becoming more and more a basis also for countries that are close or that are far from the European Union. And the topic that I'm going to assess today is related to a new technology, which is a technology which is gaining more and more traction. And I'm talking about blockchain technology and the relationship with the GDPR. And so basically the problem is understanding if the main rules of the GDPR can find application in case of blockchain technology. I think that the first issue to determine is exactly what do we mean with blockchain. And there are several ways to describing blockchains. I would say that it is very important to start from two elements which should be always bear in mind. And basically the first one is that we are talking about a decentralized system. So we don't have a central authority that stores the data, but it is decentralized. It means that every computer that is part of this chain basically stores the data of the blockchain. And given that we don't have an authority, we also don't have another element which is normally there in the non-digital world, which is an intermediary. And the absence of an intermediary gives the possibility to the user to do what? To do transactions on these blockchains. And basically, it is possible to transfer assets from one person to the other. And this, there are validators within the blockchain that basically validate these transactions. And this is in a nutshell what a blockchain is. And why is blockchain important? We have to distinguish two types of blockchains. The first one are the so-called permissionless blockchains. And here basically we don't have an authority. We are talking about a public environment, a public network of computer in which it is possible to do transactions. I do some examples so that it is easier to understand. For instance, Bitcoin is a public blockchain. Ethereum is a public blockchain. It means that every interested person can join the blockchain and become a validator. And this means that basically every person can become a person that controls data of people that do transactions over the blockchain. And the other type of blockchains are permissioned blockchain. And in this case, we have a kind of authority that can be an entity or that can be a natural person that controls the access to the blockchain. It means that not everyone can join the blockchain simply by connecting the computer to the chain, but you need an authorization of a person. Now, in my speech, I have only 20 minutes of time. I'm going to focus mainly on the first type of blockchain, the public blockchain. But a lot of things that I'm going to say are also related to the other blockchain, even though the problems from a GDPR perspective for permissioned blockchains are less, let's say, difficult to solve. So let's focus on the public blockchain. As I've said, everyone is able to connect the computer to the blockchain and to become a miner or a validator. It means that basically this person will store information on its computer. She will be part of the blockchain. Now, which is this information? We are talking about data, but we don't find the name of the persons. We don't find Francesco Paolo Patti nor Zohar Efroni. We find a string of code. So Francesco Patti is basically showed as a very, very long string of code of numbers and of letters. And so you cannot immediately say this is Francesco Patti. Nevertheless, we know that GDPR applies also in cases in which the data is pseudonymous. It's very difficult to say, but pseudonymous data. So it means that basically you have not a direct reference to the natural person, but you have data that gives you the possibility through the use of different set of data to arrive to understand who is the person who lies behind this data. So in blockchain, everything is pseudonymous in the sense that you see only this data, but that through additional information, it is possible to understand who makes the transactions, who transfers the digital asset from one person to the other. And therefore, this is the first check that we do in GDPR. We try to understand whether the regulation is applicable. And we had to say, yes, we deal here with personal data. It is not shown in a direct way. Nevertheless, it is possible to understand who is the person behind the string of code, as I've said before. And so we have to understand, but who controls this data? And here we face an enormous problem, because all the GDPR is basically connected to the idea that we have a central authority who is accountable to do something. And this central authority is called controller in the GDPR. The controller is the person that is responsible for the processing of the personal data. And it means that basically he has to fulfill all the obligations related to the processing of the data. He had to take the consent of the persons in cases in which he wants to proceed with the processing of data. And he has to fulfill also these fundamental obligations, as for instance, the right to erasure, the right to have access to data, and other rights that are recognized to the data subject. And therefore, understanding who is the controller. If we look at a permissionless blockchain, we don't have this central authority. And so we could perhaps argue that every person that joins the blockchain is a controller. And in the GDPR, we have also the possibility of having a joint control of data. And so here we should say that basically every computer becomes a controller. And this is a first problem, because it would be perhaps exaggerated to say this, because the person who connects to the blockchain is also a user of the blockchain. And therefore saying that he controls data is something which could have the significance of going too far. And therefore this is a first problem that we have to face. And it's a central problem, as you may understand, because we are dealing with a lot of people. It's decentralized. It means that basically every person in the globe can join the blockchain. The scope of application of the GDPR is very, very wide. And so it is possible that we have a myriad of controllers within the entire world. And we know, and this is something which should always be kept in mind, that GDPR presents itself as a system which is neutral with respect to technology. Neutrality is one of the main issues, and so the assumption is GDPR applies always. It doesn't take into consideration the type of technology. It takes into consideration the factual circumstances of having the processing of personal data. Nevertheless, we see here that technology poses an immense problem because it is impossible to apply in an effective way rules of blockchain against every person that may be assessed or considered as a controller within the blockchain. Another problem of the blockchain technology is related to the fact that the system, now I say another key word, is considered a append-only system. It means that you can add information to the blockchain. For instance, if there is a new transaction between Professor Efroni and myself, this transaction will show up on the blockchain. I transfer Bitcoin to Professor Efroni and he will get an amount of Bitcoin. Professor Efroni can then transfer this amount of Bitcoin to another person. All this record of transfers remains in the blockchain, visible to every person that joins the network forever. And this is also something which is very strongly in contrast to the parameters of the GDPR. Because the GDPR imposes, first of all, a principle of data minimization. And so the idea is that you have to reduce as much as possible the data which is stored in the system. And here basically we could say that the data is needed because it is made in order to ensure the certainty of the system. If you buy cryptocurrency, you want to be sure that you are the true buyer, and in order to do it, the system of the blockchain gives you the possibility to see all the chain of transfers before, and this gives, let's say, the possibility of having certainty on the system without relying on a central authority. But this means that data minimization does not make so much sense if we attach to this principle also the duty to eliminate data which is not useful anymore. Because the data on the blockchain will always be useful if there is the need of reconstructing this chain of transactions. And this characteristic of append-only system is also problematic in the light of another issue, which is one of the main rights that the data subject has according to the GDPR law, which is the right of erasure. You know, and we have also very important case law. I'm sure that it was also mentioned during the conference, the case Google Spain, and also the change provided in the rules within the GDPR that took into consideration this very important decision of the European Court of Justice. We know how important it is. In order to grant privacy to the persons, it is possible to eliminate, if there is, of course, a ground to do so, information, and to have a connection with the controller and ask for the erasure of the data. This is technically not feasible on the blockchain. Everything remains there. And this is also a very important obstacle to the application of the GDPR. And so one could say, yes, but what is the European Union doing in order to address this issue? It is a very complicated one, also because blockchain technology does not only pose a problem with respect to GDPR, it poses problems with respect to other legal issues, which go from the monetary system to the financial system to the protection of consumers. And so it is not like a special situation in which the GDPR finds itself in assessing these juridical problems of blockchain. But one can say that GDPR has particular problems in finding application to the blockchain. And in reality, nowadays, GDPR is simply not applied when it comes to blockchain. If you connect to a permissionless blockchain, Nobody will ask you for a consent in becoming part of the blockchain or in making a transfer of cryptocurrency on the blockchain. It simply is a technology that does not recognize the possibility of applying the GDPR, and also the players on the blockchain would have troubles in finding a way to apply GDPR, because if the transaction is made through smart contracts, then it means that you cannot ask to the sender of cryptocurrency to give a consent for the perpetuity of the registration of data on the blockchain. It is something which is really unfeasible now from a legislative point of view. But the European Union knows the problem, and studies were made with respect to this issue. I want to mention one which is very important. It is a study conducted under the supervision of the European Parliament on the blockchain and the general data protection regulation. And the question which was posed, and there you will find a lot of answers, is 58 pages, so a lot of more information about my compared to my speech. And the question is, can distributed ledgers be squared with European data protection law? And this is a study of July 2019 of the European Parliamentary Research Service. A lot of important academics took also part to the study. And if you finish, now I was not part of the research group, but you can really feel that it was problematic for them to finding answers to the problem. And basically, in the end, you find a list of questions which are very difficult to answer. So the idea that you have in reading this paper is that in the end, you have more questions than answers if you deal with the application of GDPR to the blockchain technology. But there are also important findings. So, for instance, from a regulatory point of view, what should we do? What should the European Union do? Create a particular set of rules for data related to blockchains, data on the blockchains? Do we need some particular rule? And the response of these experts within this paper seems to be, no, we didn't. We have a general framework, which is the GDPR, and what we have to do is providing guidance for operators in order to have possible applications of these rules. And to be honest, there are like technical ways in order to enforce the GDPR within the blockchain. We have to imagine that from the beginning, if you create a blockchain, you may perhaps provide a storage which is not on chain of data of the person. There is also something which is called zero knowledge proof, which basically could be a tool to assess the existence of a transaction without revealing the data of the person that does the transaction. And this is something so that for the future can work. The idea that you have to create this technology, but also being compliant with the GDPR. And this is true, but nevertheless, we have the blockchains that are there, that are public, and it is very hard to imagine a way to apply the GDPR. What has been done with respect to blockchain technology? The European Union is also trying to regulate blockchain from different point of views. For instance, with a regulation, there is a proposal for a regulation on crypto assets. Crypto assets are the main asset which is transferred on the blockchain. And it is abbreviated. This proposal for a regulation of the Commission is called MiCA. And one of the critics that were made against this regulation was really related to the fact that it does not take into consideration the problem of data. And also there you've seen the difficulties of the European Union to assess these problems. But nevertheless, in some consultancies that were given with respect to this proposal, it was argued that the person that issues the cryptocurrency, so not the validator on the blockchain, but the person who at the beginning sells the cryptocurrency, for instance, in an ICO, so a public offer to buy cryptocurrency must take into consideration the rules of the GDPR and so apply all the indications with respect to consent, with respect to data minimization, with respect to proper storage, all the rules that we know. And this could be important from a political point of view and also from from a practical point of view, because it means that the persons that basically exercise the main activity on the blockchain, which are the persons who deals with cryptocurrency, begin to be aware about the existence of the GDPR as everyone else in the world, and try to be to respect the legal standards of the GDPR. This problem of privacy is not only a problem of the European Union when it comes to the application to the blockchain technology of requirements of privacy. And so I think that a methodological approach should be really understanding that the technology is global and trying to work with all the partners in the world. We have the same problems also in the United States and in Asia and in every country of the world, and trying to find a solution that could be really a global solution. Because my impression is that the GDPR does not fit with the blockchain, and therefore some particular adaptation of this rules will be needed. Thank you very much for your attention.
Thank you for your presentation. And ikinci oturumun ikinci sırasında Sayın Profesör Doktor Halil Akkanat sunumunu gerçekleştirecek.
Will be delivering his speech. The floor is yours.
Değerli başkanım, çok teşekkür ederim.
Esteemed President, thank you very much. Esteemed Chairman, thank you very much.
Arkadaşlar, evet.
Esteemed friends. Yes.
Benim sizlere bu oturumda anlatmak istediğim şey,
The thing that I'd like to mention
Avrupa
in this
Birliği'nin
session
2019
is
Taksim 770 sayılı
the
direktifi
changes
var biliyorsunuz konuyla ilgili.
with respect to
Bu direktif
GDPR.
Avrupa Birliği
There is
üyesi
this European Union
ülkelerin
Directive
bu
numbered
direktifte yer alan ilke ve
770 in
kuralları kendi iç
2019,
hukuk sistemlerine aktarmasını öngörüyor.
There are certain
Avrupa
changes
Birliği
that must be
düzeni
made for
içerisinde
countries to
öngörülen
transfer this
gereği,
directive to the domestic law.
Almanya
This is what is stipulated in the European Union law, and
sisteme
Germany
dahil ülkelerden birisi
is one
olarak
of the countries that
kendi
is included in this
yükümlülüğünü
system.
yerine getirmek
Germany,
üzere
in order to
Alman
release
Medeni
its
Kanunu'nda
obligation, has
BGB'de
made
yani
certain
bazı
amendments in
değişiklikler
German
yaptı.
civil law
Bu
in
değişiklikleri
BGB.
kısaca ben
There were certain
sizlerin
amendments, and I'd
dikkatine
like to
sunmak istiyorum.
share
Yalnız
these
baştan şöyle bir
amendments
açıklama
with you.
yapmam
First of
lazım.
all, I'd like to say thank you very
konuşmada, bu
much, and in the
sunumda
very beginning, I'd
yapılan
like to make this
değişiklikleri
explanation.
bütünüyle
All
aktarmak
these
gibi bir,
amendments are not going to be
hedefim
covered
yok.
in this
Bu
presentation, of course.
değişiklikleri veri koruma hukuku bağlamında bu veri koruma meselesini ilgilendirdiği ölçüde
And I'll be giving these amendments that are in line with the GDPR. This is the outline of my presentation. So as I've stated beforehand, in European Union, there are certain developments, and from top to bottom, from the central, there are certain directives. These directives are published, and then member states are obliged to follow these directives. According to the their harmonization law, they adopt these law codes into their domestic law. And in Germany, as I've stated beforehand, we saw these harmonization attempts, and in German civil law, German government made certain amendments, and I'd like to share those changes with you. So, what did Germany do? Germany switched into new type of contract-based civil law. So it was arranged in that way, and digital products were also included as certain provisions. It is newly adopted amendment, two things were mentioned as digital product. One of them is digital content, the other one is digital service. So digital products and digital product-based contracts has been defined. In terms of data law, maybe the most important step among these amendments is as follows. They said that in consumers agreements, in consumer contracts, by the way, this is adjusted as consumer contracts. I needed to say it in the first place. In these contracts, including digital products, this is the biggest and maybe most influential issue with respect to data protection. They said that in these contracts, consumers can commit on providing their personal data as consideration. So they can bail their personal data for hire. It could be used as consideration, and it is added to the civil law of Germany. As I've stated before, and German civil law accepts these as consumer contracts, and there are some non-consumer contracts types as well. This is related to the businesses, entrepreneurs having the data and processing the data, contracts that are signed among these processors. This is not a contract of consumers, but this is related to the issue where the consumer contracts are arranged. That's why it is also mentioned in the newly harmonized, adopted civil law. Digital product is the matter to this contract, and as I've stated before, and there are two important concepts accepted as digital product. One of them is digital service, the other one is digital product and digital content. So first and foremost, they must be defined. This is to be acknowledged first and foremost. So they say that for digital content, it is something which is comprised and produced in the digital way. This is the data you established and used in the digital way. So digital service is also described as something that is enabling the production of data for the consumer, processing or storing of the data for consumers, or else these are certain instruments enabling consumers to reach the data, or else this is again every kind of services which enables all the digital data usage. I know it's a very long description. It's very difficult to translate. It's a very long description, I know that, and of course, but every detail has been taken into consideration, and everything in this respect has been defined one by one. So everything which is in line with data, or data use, or data coverage, so anything, any activity, any event which includes data in its essence could be described as digital service. Yes, after this amendment has been made, what happens, for instance, what are the consequences or else effects of this change? If we ask this question to ourselves, then we can say thanks to this amendment, consumers could also be protected with the consumer protection regulation in this kind of contracts. So in the German civil law, there are certain regulations, methods, ways, means to protect the consumers. For instance, how to establish a contract in its simplest words. So the code of procedures should be applied as an entrepreneur. What do you need to do? First and foremost, you have to apply this consent obligation, and after that you have to explain everything to the consumer in the way that he or she can understand. And in the establishment of the contract and in the payment of the debts and obligations, and also performing all the acts should be arranged according to this contract amendment. So in this framework, digital consumer contracts with respect to digital products are again arranged under the title of contracts for digital products. So no matter what the type of the contract is, if the content is digital product, without discrimination, everything with respect to digital products, no matter what the kind of the contract is, all these law codes should be applied to the contracts. So what should we understand from the description in this part? So for instance, there are different types of contracts, like sales contracts, or else if it is free of charge, then we might say it's donation contracts. If it is not handing over a property, if it is only providing the use, it is a rental contract. And if it is something that a person takes a return, on return of something, a person might be providing service, it could be contracts of labor, etc. Or else it could be contracts of attorneyship. So based on the act, based on the performance, contracts are named. So what we understand here is that no matter what you name these contracts, it doesn't matter at all. So what kind of a contract we are talking about, again, it doesn't matter. If it includes personal data, and if it is decided as a consideration, and if it is given as a consideration again, this is more than sufficient that these are also evaluated under the title of contracts for digital products. If personal data term is uttered in any kind of contract, this is more than enough to apply the relevant rules. When we talk about performance or provision, or else consideration, so personal data could be used in a contract, or else that personal data is permitted to be processed. If it is accepted in a contract, then there are very important legal consequences. What are those consequences? Previously, I've tried to mention, and you can understand those examples if you pay attention, in those contracts. By taking basic performances into consideration, we allocate legal attributes to the contract. One is sales contract, the other one is the contract of attorneyship, the other one is rental contract, etc. So when we decide on a consideration of personal data, if it is made possible, will it change the type of the contract? So when we determine the type of the contract, we should also take this issue into consideration, and we might say, it was a sales contract, but right now it includes permits for use of personal data. then will it change the type of the contract? Should we be questioning this? We need to answer to this question, but the answer to this question is not available in German Civil Code because it's not arranged like that. But the generally accepted perception is as follows. So it is said that personal data, and when it comes to personal data processing, if it is performance and act or consideration, no matter how we describe it, it does not create any effect of the renaming of the contract. So before the contract is kept as its original form. This is how the majority accepts the situation, and I'd like to mention that again. Yes, sometimes it could be accepted as a performance, and of course it might lead to certain consequences. When we say performance in the classical Code of Obligations, what do we understand? For one side, when we talk about performance, so you should also understand it as an obligation, right? So if we call it something as obligation, what does it mean? For the other party, it means that there is something to get, there's something receivable, and that receivable thing should be executed, should be fulfilled, and it could be also, it could also be litigated. So if it again includes data protection, what about the other party? Can they ask for the execution of this performance or not? If you say yes, that party can ask for the execution, maybe for the, if you say yes, they can ask for the execution, you will reach to different consequence. Obligations, or else some rights for obligations, what do we say to them? We call them full rights for obligations, because the creditor has the right to get the power of the legal system to get what he is asking for. But if it is not something that could be litigated, then this cannot be defined as the perfect obligation. It is called as imperfect obligation, like the obligations that are imperfect, like the statute of limitations, for instance. If there is the statute of limitations, then you say that there is nothing that to do. If that person wants that, he or she can ask for the execution, but the creditor can't ask for the execution of the performance. Is there anything in German Civil Code about that? No, there is no adjustment. Legal people should come together and actually discuss about that and come to an end. When I talk about a performance, this is very important. Again, when we talk about performance, it should not be ignored at all. If it is obligation, it is executed, let's say. So whether there's going to be obligation of warranty of the debtor, and let's say partially this obligation is explained, because when you read your newspaper, for instance, on your laptop, so those digital platforms, they are watching you. They see which pages you are paying attention, which columnist you are reading, for instance, whether you are looking at agricultural news or not. So they are actually watching you when you give your consent to be watched and followed. You give them the right and obligation to follow you, and you have given your consent, and this is something that you have executed. This is a continuous relation. But what you have done in this in the computer's program, there are certain acts that you can use that can prevent that debtor-creditor relationship, and then you made your personal data not shareable. So is it against your initial commitment or not? If it is against, then it means that the other party, the creditor, can they say something to you or not? This is again very crucial for the consent of personal data use. This is very much related to the legality of the consent. And also in German civil code there is no selection with respect to that. However, it can be deemed as a legal problem, and we have to pay attention to that, and we need to definitely eliminate it.
Tam da bu noktada
At this very point, the consent given for processing the personal data, can it be taken back or not? This is an important matter as well. Why? In a contract, for example, there is a date of action. I will let you use my personal data, and this is continuous obligatio. And as in the example I gave, in the middle of the path, you say that I don't want to share them with you anymore. So what happens? The classical approach is that this is against the obligation, behavior against the obligation. And what is the sanction in the code of obligation? If it is possible to make the same action, then okay, or not, compensation for the loss. This same principle, can it be applicable in terms of personal data? We need to be focusing on that as well. This is also one of the fundamental questions to answer. And here, the German lawmaker stated that this consumer can take the consent back whenever he wants or she wants. Okay, you gave your consent, then you took it back. This was a fundamental element of the contract. It was an obligation, but now you say that I'm not going to fulfill my obligation. And the lawmaker says that you can do that. And then what's going to happen for the counterparty? What are we going to tell them? If it had been an obligation, then this is an action against the obligation. Then you need to come up with a solution accordingly. But in terms of personal data sharing, this is all about the legal quality of the personal data. This is personal data, and the consent given at the beginning can be taken back. There is no need to make any explanation. So it's possible. So in such a case, we need to be carrying the counterpart as well, and the counterpart is set by this new regulation that if such a case happens, they can terminate the contract. One party can take the consent back, and the counterparty can terminate the contract. If when you terminate the contract, in the classical code of obligation, this is the severe breach of obligation, and there should be a sanction. So if this termination is rightful, then those who terminates the contract, they can ask for a sanction or compensation. If not rightful, the other party then may ask for the compensation. If we look at personal data from this classical code of obligation perspective, we can consider them as the non-rightful termination. But here it says that in line with the quality of the matter, only the authority to terminate can be used. No compensation demand can be asked. What can happen? Only if there are some in advance advantages to be used during the time, then they can be taken back. That's all. No compensation is mentioned in the law. Could you wrap up, please? At this very point, this is managing, this is arranging the relationship, and update is very important in that regard. And in such contracts, updating obligation, if the obligation relationship continues, the expectations should be updated, even if the risk of obligation ends. And this updating obligation has to be fulfilled. When we look at this updating matter from the perspective of the data law, this updating obligation, does the consumer have such an obligation as well? What do I mean? You exposed your personal data and you let them use it, and as the contract relationship continues, there's a change in your data, and you as the consumer, do you have to update that data? There's no regulation in that regard. When I say updating obligation is a part of this matter. Apart from that, about timing, there has been put some arrangements, and proof of burden. Normally in the civil code and in the procedure code, burden of proof is on the person who alleges, who make the allegation, but this burden of proof in terms of the contracts about digital data, it changed places. The consumer is obliged to prove his obligation. And last but not least, there is one more amendment. It is about not the relationship, contract relationship between the debtor creditor, but between the consumers. 3 or 4 articles, I'm not sure about the exact number. This recourse relationship has been arranged. You gave your personal data and you have the right to take it back freely. And the counterpart signs an agreement with someone else, with a third party, by trusting your personal data. So they create another legal relationship. But on the way, you take the consent back. But what about the result for the third party. Now, this entrepreneur, what is he gonna say to the third party? What is the result? So there is a result of the consent and kind of legal litigation that might occur between these two consumer party. Thank you very much. I kept it too long. Thank you very much, Professor Dr. Halil Akkanat. Now, Professor Dr. Murat Atalı is going to take the floor. Thank you very much.
Halil Akkanat'a çok teşekkür ediyorum. Benim için çok yeni olan bir anki fasih.
Very much. You have touched upon this very new topic in a very explanatory manner. I've learned a lot. Thank you very much. And I'd like to confess one thing. The personal data controller owner has the right to terminate this contract where data is deemed as performance act if the legal party has the same provision. How to execute this? I mean, I was really curious about what to do if this condition is a different one than the stipulated version in the law. I mean, you really saved me from thinking further. Of course, my presentation is not going to be that technical. It's not a very special new information including one. I'll be talking about the principle of publicity and during litigation how to protect personal data on the principle of publicity. The principle of publicity is a fundamental principle and it is also related to judicial fundamental rights, and Professor Burak is a very known professor in this respect. In the Constitution law and in the civil procedure law in the European Convention of Human Rights, it is evaluated, and the principle of publicity could be deemed with different terminologies, but we can say that it is the reality of the public sphere and public's opinion. So this is the establishment of the trust of the public towards judiciary, and an act should not be kept as a secret on the eyes of the public, so that public should not should know whether the authority that they has given to the judicial courts in the best way or not. There are different types of the principle of publicity. One of them is the direct one, the other one is the indirect one. So in the direct one, everyone can actually come to the hearing courts and they can watch these hearings, trials. So this is the direct publicity. So very closely they can witness the acts of trial. But the other one, the indirect one, is that through these mass communication instruments, hearings could be open to the relevant or irrelevant bodies. So other than this, when we think of the dynamic and static versions, actually, when we say the dynamic one, this is the principle of publicity of the hearings, and the static one is related to the publicity of the announcement of the court decision, court decree. We don't have to use these terms, but when we use these terms, you can understand the situation in a more conceptualized manner. This is what I think. And also in the civil procedure law, we say that hearings and decrees announcements must be public. So the announcement, the notice, that way is very crucial. But I think that word is a bit problematic, because in the civil procedural law, there is no term saying the announcement of the decisions. There is the submission of the decree. There is the declaration or statement of the decree. But when we say stating, this is something else, or notifying is something else. So actually, so the announcement, declaration must be used, and also the dynamic one, whether before proving their relevance to the hearing, anyone can watch the hearing trials. This is the dynamic one and the direct one, and also the announcing pronouncement of a judgment can be given in the principle of publicity. This is also the static publicity. And in this principle of publicity, we see Constitution, Article 141, and European Court of Human Rights Convention, and also in the Civil Code law, procedure law, the principle of publicity has been accepted, but there are certain limitations. Maybe from the Constitution law number 141, we can't get many limitations, but from the European Convention of Human Rights and also from other civil procedure law, we can see certain limitations when the general morality and also public order is taken into consideration. In civil procedure law, we can see certain limitations. And at the stage that we are in the also opening speeches, it has been mentioned, and previous speakers have also mentioned that before me. There is this new concept which is at the agenda of the modern law systems. Data protection should also be added to the publicity principle. Because when we talk about the principle of the publicity, the requirement of the protection of the personal data could be in conflict during trials. Because during hearings, during trials, on the defendant side or on the plaintiff side, because of their positions, when they try to explain their righteousness in order to win the case, when they prove certain cases, sometimes, technically speaking, they can be accepted as personal data, especially against irrelevant third parties. A disclosure of these personal data should be not brought to the case, or else they should compromise their possibility of not winning the case. I guess these are certain things that no one wants to take as a risk, and modern law systems will not also protect these choices. This is what we understand from the previous speaker's presentation, because modern law system can't create a scene for people to make this choice. And in our implementations, we can see many examples. And I'm not going to read you the details of this decree. There was this individual application to our constitutional court. I guess it was related to termination of the labor contract. And one of the persons, HIV positive persons, confidentiality demand was breached, and this also was related to personal data protection and right of personality. Hearing should be made in a secret way. It should be opened in a, it should be proceeded in the closed place without hearing other people, but it was not accepted by the court. But the Constitution said that it's a breach of personal data and personality rights. So there's no need for us to explain personality rights. Maybe for us, I try to also mention that beforehand. So because of the position of the person, whether they are giving their claims or defensive claims, if it is personal data, it might not they might not want to use it against third parties. This is a problem which is also discussed all around the world. And if it is an irrelevant third party, it must be protected against that. And where are the judicial instruments placed? We need to know this. So we, of course, know what is personal data or not. I don't know. I'm not going to dwell on the details of it. But there is this case that I'd like to give you another example. If this issue is also personal data, if there is a demand for not disclosing this information, then during the hearing, how can we facilitate not disclosing this personal data? Can we find such instruments in our procedural law? So elimination of the publicity is the most influential instrument that we have. So the hearings could be kept in confidentiality and secrecy so that other parties could be out of the hearing. And as I've said it before, in Constitution Code number 141 is not very explicit, but I'm also going to read you the European Convention human rights articles. It used to be very influential and very beneficial for us, but our law, civil procedural law, is not also in line with the 6th article of the Human Rights Convention, European Convention of Human Rights. And this is something that we all know very well. That's why I'm not giving you the details. So there is a 28th article of the civil procedural law. There is this amendment. I'd like to mention that. In the 28th article, in this new, before it was changed with the new law numbered 7815, it used to have this feature. Some or whole of the hearing could be kept under closed doors when the security of the public is needed. It could be given with the decisions of the court. So the secrecy confidentiality case is only possible when need for public safety and security is needed. So it could be associated with the public order and public safety, security. But I think it's something very challenging. And on the civil procedural law, in 2011, it was enacted and it was already finalized in 2006-2007, but it was enacted in 2011. So if we think of these features with respect to modern personal data law, we were maybe right to say it should have reflected all the repercussions of the General Data Protection Law, but on the main Constitutional Law 141st article, there is no parallelity, and there could be such arrangements like this. But in time, we understood that this was not sufficient. For that reason, there was need for a change, and we adopted these new changes. And in our implementations, we checked the relevant law. And in the European Convention of Human Rights, when there is a demand to the court, if we say this is the law from our domestic hearing courts, I believe the progress of our courts are not very positive. So for that reason, in the 28th article of the civil procedural law, there was an amendment with the law number 7815, and this is the law goes on. Hearings, trials could be kept under secrecy when the hearing could be creating safety, security, or order-related problems for the public. Up until this, it was old, and if it also says that if upon demand of one person's side, decision for keeping the trials in secrecy, confidentiality could be also decided if personal data protection is required. If the third parties best benefit is including personal data, then we can also talk about confidentiality and secrecy of the hearings.
Dikkate alındığında
Therefore, the protection of private data on the basis of that, when they want a secret hearing, there is an article supporting it. Let me tell you that there's a new and positive step. Not only the parties, but also third parties are included here. I mean, the protection of third parties are included as well. Who might be those third parties? In the, for example, divorce hearing, personal data about the situation of the kids. What is the issue with this arrangement? Here it is, in my opinion, of course, an interest which is worthy of protecting should be certain. This condition is quite heavy. From which level this protection is worth applying? It's not clear. Should that be carried to this high level, you know? Here, of course, publicity principle is given a wholly importance and meaning, and it is also shown here with this approach. I'm trying to catch up with my time, so I will skip a couple of points. For protection of private data, by making use of 28th article, secret hearing can be decided by the judge. Let me skip technical parts. May decide secret hearing. This is also very important. If it is proved that it is necessary, then it should not say may, the judge may. Instead, it should say the judge will decide. So this may gives the right to the judge to make his own decision. This is my opinion. The court can take secret hearing decision, and only related parties will be included during the hearings. And apart from the judge and the parties, no one is going to witness that hearing. So it's going to be indirect publicity. I mean, the hearing cannot be announced by mass communication devices, and in 285th and 286th articles of Turkish Penal Code, the sanctions might be applied. In the first paragraph of 28th article, the notification of the decisions are included, but that word, notification, or the communication of the decision, you know, there is an issue born with this word. At the end of the oral trial, the short decision, at least the short decision, I mean the final decision of the court, other problems may arise, some technical problems may arise, which is not going to overlap with the terminology. Let me give you an example. C paragraph of 289th article says that the provisions, total of them, the evidences collected and the litigation matter, the collection of the evidences, and also the results and legal reasons are there. If the decision of the hearing has taken consideration all these matter, they will include these elements. The short decision is going to give us the final decision of the court, but normally this decision should be including all these elements. The decision, verdict, normally should be read, and after 1 month the justified decision should be written in a month. When it's written, there might be another issue. The decision making happens at the end of the announcing of the decision, happens at the end of the hearing, and the short decision is being read while those in the courtroom are standing, and the decision is being announced and then written on the minute. If the hearing is secret or closed and the announcing of the decision is going to be made during the hearing, from the procedural perspective, the announcing of the decision, how are we going to separate it from the final verdict of the hearing? Because the procedures about the oral hearing, everything has been completed, and the judge is going to announce the verdict, but the courtroom is closed to other parties. The hearing continues. The procedures have been completed. We can open the doors of the room. Are we going to say that during the verdict? And this should, it's not possible to arrange these matters with the article because we are still in the hearing, and those only in the hearing can listen to the announcement of the verdict. This is clearly stated in the law. Because of this reason, in the hearings with privacy decision, the announcement of the verdict is within that private approach, and my approach is not accepted by the rest, but Hakan Pektas is agreeing on me. And in terms of European Convention on Human Rights, the publicity of the announcement of the verdict is arranged very clearly, and in the scope of, in the context of European Convention of Human Rights, this vast majority, overwhelming majority, should be in the verdict announcement, but there are also minorities who are thinking parallel to me. I believe that this idea is going to be accepted by more and more judges because, as I tried to explain at the beginning, that publicity principle, which was attached traditional and holy meaning. By the way, another matter that's worth mentioning about the publicity is that during the hearings, everybody who proves their relation to the case has the right to examine the case file with the permission of the judge. When you examine the case file, you are, you're reaching more information than participating in the hearings, because the actual information is in the written petitions. Therefore, if you have the access to the case file, you are more knowledgeable. The minutes of the hearings, they contain less than the case file. So, if you having an access to the case file should be handled very carefully, rather than discussing the publicity of the hearings. And in terms of the files about which secrecy decision has been taken, we need to be careful. Please wrap up. The judge, if the private data has to be protected, the judge should be careful while letting people have an access to the case file. Proving interest should not be enough alone. And last but not least, the publication of the verdicts. They are important. It's the continuation of the publicity, and also it's the practical result. It creates a value, etc. This is important publication of the verdict, but a verdict which includes a personal data, as I stated earlier, 297th article, I read that. The evidences, its discussion, legal qualification, etc., they're all going to be within the verdict. You don't need to look at the case file. You can just read the verdict, and then you can reach the personal data that you would like to see. At this very point, the verdict should not be published. The private data should be anonymized or kept hidden. As a result, the historical journey of publicity principle, it's about a panel jurisdiction, panel judging, because, it's about the protecting of the public interest. It's mostly about it. And in civil code, about the private law, about that, the personal and individual interests are up on the table. The rights stemming from the spatial law, and when you look at that from the perspective of the civil code, not transparency but privacy, not publicity but secrecy should be considered more. And in the perspective of the protection of the private data, there is no reason to make any discrimination between two types of judging, because, the instruments substituting the publicity, we do have that, and in the high interest, protecting the private data should not be neglected. All the parties are being represented by the lawyer, most of them at least. All the hearings should be recorded on minutes, and only the required personnel during the hearing should be there, like the judge and the writer, and to degree low path system should be brought, and publicity principles historical function has only symbolic meaning, and private data protection has become more important than that.
Doktor Murat Atalı'ya sunumu için çok teşekkür ediyoruz. Sıradaki konuşmacımız Sayın Profesör Doktor Burak Gemalmaz. Buyurun Burak Bey.
Çok teşekkür ederim Sayın Başkan. Herkese saygı.
Thank you very much. It was very inspiring for me to listen to and also to listen to the previous speakers. And it's very technical and very sectorial, as we can see. And we see the connection to fundamental rights is ignored. Personal data is also fundamental rights. So we need to also see this issue from the perspective of basic fundamental rights. When this law was enacted in Turkey, it has been ignored, unfortunately. It has been neglected. There is this law, however, unfortunately, this law does not cover huge areas. So there is this some warranties, principles that are brought by this law can't be applied in certain areas. These areas are the areas which is intervened by the violations of the fundamental rights. So before this law was enacted, there had been many issues about personal data, and they were handled at the Constitutional Court and European Court of Human Rights. And this awareness maybe was created a bit late, and it wasn't understood as a real concept. In the 1960s, we can actually say that there were certain cases. For instance, in the identities of our ID cards, there was this religion part. And with respect to the Constitution Court, did not see any problems in 1960s, 1970s, 1980s. But they did not see this issue from the fundamental rights perspective. But we all know that personal data, there is a European Convention with respect to processing of the personal data as of 1980s, has stipulated the fundamental rights perspective of the personal data. And we have this new GDPR, and the new amended principles are very much related to Human Rights Convention numbered 180. For the first time, these issues were uttered. So when we look at the very essence of the personal data, it was all about personal rights, human and fundamental rights. But we know that science and technology developed too much, and it actually distorted this connection from fundamental human rights. And right now it's at a different position. And here there is this bottleneck at this part of the human rights and fundamental rights. So my topic is related to the performance of the Constitutional Court with respect to personal data. Actually, I find it very difficult to classify the performance and score the performance of the Constitutional Court, because we know that when it comes to lack of definition of personal data, when personal data was not defined in the past, Constitutional Court decisions were not favoring the fundamental rights. It was mainly about the Constitution's main principles, like the state sovereignty and some other very main domains. And if you remember back then, there was no right to apply individually to Constitutional Court. There was only cancellation court cases, or else there was only objection to some court cases. For that reason, Constitutional Court was not making evaluations over fundamental rights. For instance, in 1990s, it was about ID cards religion part, because as of 1970s in Turkey, we had many regulations, but the ID card additional obligations were also reframed in 1990s so that the law enforcement officials could reach to some information more easily. But for them, for Constitutional Court people, let me say in that way, it was not a problem. But in 2020, in 2002, they said that it was related to fundamental rights. Personal data is the right to be protected. And at that moment, personal data, under what item it is affiliated, because personal data is not written in constitution or in the international law back then. So it was not very certain with what law it must be interconnected, but in the constitutional terminology it was privacy rights. And in the European Convention we can say that respect to private life. So when you see personal data as a respect towards private life, or if you just arrange it as privacy law, then you can see some intersection and intermingling of the law and codes together. So different situations should be defined under the same laws. So at the very end you actually confuse certain things. Some law should be under this certain concept, but certain problems prevented us doing that, and I'll show you some examples with the decrease of Constitutional Court. In 2010, as you all know, with the constitutional change, certain articles and paragraphs of the Constitution changed, and the private life arrangement, personal data protection was a bit changed. Again, normative structure was again empowered, enriched, and at that article it says that related issues about the topic could be only arranged with the details coming from the constitutional law. And I can tell you that the principles protecting personal data with the subject of the right, or else the owner of the personal data, participation about these people was also added to the article. And in the future disputes, I believe that Constitutional Court will have some space for them. But I think I still find it very difficult to give a score to the performance of the Constitutional Court after 2010, because when it comes to individual applications and the cases for cancellations for the Constitutional Court, I found, and I maybe intuitively felt, that there was a different approach. And in law, we are not very much familiar to using empirical methods. Normally we sit down and we just carry out some analytical works, that's it. And based on that we say it is righteous or not. So there are certain empirical studies. Maybe we can reach to real law, or else real situation beyond what is happening, and there is this presidential accumulation of knowledge. It could also be provided thanks to that. I haven't succeeded in doing that. This is something intuition, and I can share my intuition with you. When the public interest seems the best or high, collecting, storing, and selling the personal data to third parties has not been arranged by Constitutional Court. If something is fundamental rights, then there is a regime for fundamental rights. So how you apply fundamental rights in this way? So there must be a legal basis for this implementation, and there are details of this legal basis. So this law must be reachable, accessible. By the way, I am also talking about the formal law. It must be issued by the legislative power, and it must be also predictable and understandable. So the ones who can read it need to know why it is there and how it is going to be implemented, and the ones who are not obeying the rules should know the consequences and adjust themselves according to that. This is the first step. And let's say that you make this adjustment based on this legislation, that is the legal basis. By the way, this is not sufficient as well, and we need to see whether there is a legitimate reason for the limitation for this law implementation, because it is personal data, its collection, processing, sales, or not deleting the personal data. we need to see whether there is a legitimate reason behind that. So with respect to this legitimate reason, human rights organs do not make too much investigations, but we have to say one thing. I'll be giving you the test of the interventions, proportionality, moderation test. This is very crucial for us. Principle of proportionality, and it includes proportionality, yes, and necessity, and we can have 3 different titles. Generally, the necessity and obligation is very much together, and there is the conveniency. When we think that there is legitimate reason, so it should also meet other principles. And in the proportionality, it should also be favorable, sufficient. The importance of the legitimate reason should be balanced. And all these troubles, inconvenience, should not be on the burden of the right owner. And there are some other factors like legal participation rights and also legal right to rest and legal right to be listened to. So let's say person is the right owner and that person has to claim his words in front of the authorities, and he or she should be listened to. When we have a look at these principles in the fundamental rights, in the human rights, there is these warranties for the procedural participation, legal participation. It is very much related to proportionality, and this is something that we have to be focusing on. These are some special collaterals and warranties, special warranties on the Constitutional Court. So a constitutional law should be making certain amendments. So what I have this intuition here. In the court cases of the Constitutional Court, there was not very much detailed analysis. I don't know whether you are interested in Turkey or not, but there is this PASOLIG or e-ticket application in Turkey for football games. So e-ticket implementation has become much more concrete. As PASOLIG implementation, there is this PASOLIG card. You have to have it to get electronic ticket. By the way, this information is not sensitive information. These are related to the teams that the supporters are supporting. So you know that under this regulation framework, this information is kept in the law enforcement, but there is no clarity about that, to what extent it is going to be used, whether it's going to be given Turkish Football Federation. It is not special or peculiar to football. That's why I can say it could be general, but I'm just giving you this as an example. So the main constitutional law actually ignored certain things and neglected certain other things. And there is also the Intelligence Office, Intelligence Bureau decision. So we can see there is almost limitless authorities given to National Intelligence Bureau. And Constitutional Court applies this law without respecting anything. And biometric data, in order for you to get health service, this is obliged, that you are obliged to give you your details. By the way, private sector takes your information, and private sector at least hands your information to Social Security institution over later on. And Constitutional Court does not find it harmful for your personal data to be sold to the third parties, and there was not sensitive and meticulous analysis. By the way, certain of this data is sensitive, and theoretically speaking, they must be attached with great sensitivity, and a stringent human rights supervision and audit should be applied, which is also accepted by the law. However, we can't see the reflections over the applications of the Constitutional Court. Constitutional Court says these are sensitive data, but still they are not applying the law. And there is this Statistic Institutions Court case. First and foremost, the authorities were cancelled by the Constitutional Court, but when this law was again given to them, they did not see this or notify it as null and void. And the actions for nullity, some of our applications are not implemented fully. So decision not to act for nullity shows itself in the application of one of the celebrities of Turkey, Defne Samyeli. Statistical institution went to Defne Samyeli to get some information. Defne Samyeli rejected giving the information and they gave her a fine. So Constitutional Court does not find it harmful or problematic for asking the information and not giving, and in return of not giving the information, there is this fine given to the person, the subject of this case. So according to Constitution Court, it's not a problem. So if the law was created in a different fashion, it would be much more understandable. So actually it is not very certain how to process the information within line with this law. If when we look at the factors about the personal data, how to access the data, and persons, the owners of the personal data should be included in the processing and also the correction of the personal data, and also to be right to be forgotten, right to delete their information, personal data. But we don't see those factors in the law, and unfortunately, especially in action for nullity, the Constitutional Court does not show sensitivity to these cases. And there is just one legal basis of the Constitutional Court. Maybe we can emphasize it like that. It's something that is used very frequently. So unjust, illicit acquisition of the personal data has become a crime. So this is always referred by them. They think that this is a procedural assurance. So right owners, if they are exposed to certain unpleasant data processing, this is an instrument for elimination of these unpleasant situations. So they think that they can provide this proportionality. However, here the Constitutional Court, I think, has this methodological problem, and it's going to also reflect itself on the individual applications. And I was talking about this empirical methodology. I told you that we were not using empirical methodology. I just want to remind you of that once again. In order for us to say that a remedy is effective, it's not sufficient to say and show that it's effective on paper, and we should also show that it is efficient in the implementation. So the Court of Appeals should have shown that decision was in line with the law, and the relevant cases must have been collected, and this was the decision of the Constitutional Court. And if you open a new case, you would see this result. So this must be done, and they need to say this is an effective remedy. And in terms of proportionality, it must be considered, and as a consequence of this, when the domestic remedies are finished, you can also apply to their opinions, and Turkish Criminal Code addresses to that, but there is no reference to the Court of Appeals decisions. When we think of Court of Appeals, I think they have just learned personal data processing crimes. It has been on the law since 2004, but personal data just is something new to them. And when this kind of court decisions were given 4 or 5 years ago, for instance, back then it was just a few. And we can understand that based on the research which was not made by the Constitutional Court, and I tried to screen the list Court of Appeals decisions, by the way, in our Department of Criminal Law, the Istanbul University. Many dissertation theses have been written, and still we have many theses. You can see there is no effective court decision. There is no Court of Appeals decree. Unfortunately, Constitutional Court refers to a step which has nothing underneath. That's why it collapses, and there's going to be much more consequences, and I'll show you.
The issues about the cancellation hearings, if you let them aside, put them aside, it looks like that this is a little bit better, but my intuition tells me that we should not trust it that well. This positive look, in which decisions do we see them? Let me give you an example. Safety and security research and archive research data, especially in the public sector, they are being used. Farih Saraman made an application about it, and his application, a thief crime, you know, that he committed when he was a child, was shown. But the systems, I don't know how they found out that information, and they used it in the application against the applicant. When it was sent to the Constitutional Court, without any hesitation, as there is no authority within the law, and the data usage fields are limited, it's a breach. What did it say? There is no legal base about giving that private data to the third party, and it's not legal, you know, and this is the first condition when there is a limitation, being legal. And another interesting application, Arif Cangı application. We see this sensitivity in this application as well. This applicant stayed in a hotel, and this information was given to third party by the public institutions. You know, data is everywhere. The data is protected, you know. Now those principles are not taken into consideration that much, you know. The data is everywhere, and this data was given to the third party. This is the private sector, not the public institution, by the way, and the Constitutional Court doesn't have any base, any grounds, so it was a direct breach decision, and there are similar decisions made by the court. Individual applications to the Constitutional Court, we can say that they are in a better position. And about a lawyer, for example, an activist lawyer was put in the file of National Intelligence Agency. That person has nothing to do with that, but, you know, in the file, additional info comes from the public institutions. The judge doesn't have any interest in that, but the judge is expected to be influenced by that. And in this very event, the applicant says that, why do you have that in my case file, the lawyer says, and the Constitutional Court took a decision of violation, not because of being legal. And National Intelligence Agency has such an authority, they say. As you can remember, they didn't cancel the previous court case. And when this file has been put to the case file, Constitutional Court, you know, took a decision against it. When they read the decision, you know, they said that it's because of violation, but not, you know, they didn't make that decision because of the violation. They should have stated that it's against the law, because as a public institution, you're not acting in line with the law, but the Constitutional Court couldn't say that because they couldn't cancel it. In individual application decisions, those positive decisions, we need to look deeper, and especially about the intelligence authorities. Constitutional Court hasn't shown a very good performance. We need to be clear about it. For example, Ali Chir application, and he is a public clerk, and in the agenda they took him on the list of the intelligence agency. There is a violation of private data. This is the application of this person, and when you look at that from this perspective, the country has a positive obligation. Therefore, it's about effective proceeding obligation, which is on the shoulder of the state if it is against law. Do I have 5 minutes? Do I criticize too much? Okay, the Constitutional Court says that the applicant should not go for a criminal case. They can open a court case against the management. I can understand the first part because the positive obligations in the human rights law, it doesn't require a criminal support from the state. The violator should not be condemned each and every time. However, what's the alternative? It should be legal responsibility, maybe discipline responsibility. Then what are you going to look at? Then those paths, are they effective? Full trial court case. In how many of them indemnities have been decided by the court? Wrongful action, for example, wrongful action obligation. In the theory, we do have that. And more concrete example of it, the police, for example, their authority to ask for the general data of the citizens. And when we look at the Annex 7 of the police code, enforcement officers do have the authority to collect intelligence. And there's a directive related to this, which is called as GBT, General Information Screening. There is no problem with the fundamental law, but the law should be reachable. General Information Collection Circular was not published in the general documents, it's for in-service approach. When we see in the circulars, they say that we published the circular, it's not published in the official gazette, but in order to limit the fundamental rights, the person should be knowledgeable about that limitation. But the Constitutional Court didn't see any problem about that. There is an issue about its content as well, because a text limiting the right should be certain, and the authorities are ambiguous and they're not certain, but put that aside. But in terms of having an access, there's an issue. Constitutional Court said that it's okay. When we look at that, there are two decisions. The moderation, when we say that, they didn't have any serious allegation about that. It might be, I don't know, the mistake of the lawyer. But the main thing is about collection of such information. European Court of Human Rights and the constitutional rights, they don't consider the criteria, whether that person is a convicted person, the type of the crime and the seriousness of that, the information, how is it handled, these factors. When you look at these factors, general information collection can be legal because there are data of DNA in some countries, but European Court of Human Rights didn't see any problem about that because their conditions are clear, but Constitutional Court didn't evaluate these factors, and then this intervention was accepted as a moderate and legal one. But let me tell you, after my presentation, in terms of private data protection, the Constitutional Court, that part, the law is leaving a huge amount of zone exception. Is it protecting it in an effective manner? Thank you very much. This is the question to think about. Thank you very much, Professor Dr. Murat Gemalmaz. Our next speaker is Dr. Suhar Efroni. It's your turn.
Thank you very much, Mr. President. Thank you to the organizers that allowed me to speak in this distinguished Congress. I will share my screen now with you. I have some presentation, some slides for you. Let's see that it works. Just a second. I think, I don't know if I can share this on this browser. I'm sorry, just a second. I get an error notice. No, I'm sorry, I need to re-log in from another browser. Is it possible to allow this? I apologize for this. Just a second.
I think it is possible for us.
Do you see my screen? Because I was not able to. I'm logging in from another browser. Just a second. So I'll try again. Can you see the presentation now?
Yes, we can see it now.
Okay, thank you very much. I apologize for this delay. A little technical problem. Also, thank you to the speakers that spoke before me. The presentation that I'm going to give you in this 20 minutes will talk about the GDPR as a risk-based regulation, delegable consent, and trusted data intermediaries. What are all these things mean, and how does this connect to, for example, the presentations of Professor Patti on blockchain and the risks that are involved, Professor Atalay about the publicity of judgments and the problems that are related to that, and last but not least, the last presentation about the constitutional problems that are connected to the protection of personal data. It all connects to this relatively abstract title of my presentation. This is a synopsis of the things that I would like to talk about today. They look at first glance unrelated to each other and maybe thrown together. What I'll try to do is to make a connection between them and summarize my thoughts and ideas about these topics in concluding slide. So I will talk about risk and risk-based regulation, risk regulation in the GDPR. I'll move to consent, the concept of consent, and my idea or the idea of consent as a delegable power. Then I'll connect it to the issue of trusted data intermediaries and wrap up. So what is risk? Or what is a risk not? How do we approach this concept of risk? We have different ways to look at the conceptual question. The sociologist Luhmann suggested that we need to look at risk in connection to human decision making. So these are potential negative consequences of human decision making as opposed to dangers that are not connected to what people do and how they make decisions. Some others, for example, the economist Knight has a classic work in which he determines the difference or the distinction between risk and uncertainty. So according to his view, we can look at risk from the perspective of two types of uncertainty. Determined uncertainty, we know the odds, but we don't know exactly what's going to happen. And indeterminate, unmeasurable uncertainty, which is another type of uncertainty that is associated with the different kind of risks. And there is another distinction between risk and harm, and this distinction is pretty much related to the axis of time. So the risk is there as long as we don't know if the harm will take place when the harm takes place. So this is not a risk anymore. This is already the consequence of what has happened as a result of the risk situation. If we look at definitions of risk, formal, contextual definitions, well, definitions vary across contexts, depends who you ask and what is the context of the question. There are two definitions that I summarized here just to give an illustration about the factors that people think about when they talk about risk. So risk can be defined as a range of possible outcomes that they're each associated with a certain objective or subjective ascribed number of probability. Again, we go back to the idea that a risk conceptually is connected to the ability to predict in pretty much precise approximations what will happen next or not. An example from the ISO is a shorter one, combination of the probability of an event and its consequences. And the work definition that I adopted for this presentation, we can think about risk for the current purpose as a chance for a future negative event to take place measured by the magnitude of the harm and the likelihood of its occurrence. Let's think about risk in this way. And when you read or think about risk, you have certain conceptual elements that repeat in the literature. and we usually talk about predictions concerning a certain hazard or a group of hazards, the uncertainty expected or expressed in terms of probability. We talk about the adverse consequences. This is what lawyers call the harm that could materialize. And more detailed risk analysis methods talk about timeframes of evaluation, and in every risk analysis, we have also value judgments and the perspective of the affected actors. Different people can define risks in different ways or perceive certain future developments as risks in certain magnitudes. So there is always a value judgment about the determination of the risk. So we know what risk is. Let's think about risk regulation for a moment. So we know the risk regulation methodologies and literature has been prevalent in certain contexts in the past. Environmental regulation, health and food, financial markets, banking and insurance, and occupational hazards. These are elements, or I would say sectors or perspectives, where risk regulation has developed and been applied. And the focus in all these contexts is on the anticipation of the risk and preventing its realization. So think about the environment. We want to prevent environmental negative developments that would create harm to our planet, to people. Same about food and health, chemical substances, and very important also in financial markets. So we know what's risk regulation, more or less, and we can think about risk regulation as a systemized decision-making framework. We, as an agency, let's say the Data Protection Authority or some other state agency, is trying to prioritize regulative activities such as monitoring and enforcement, and it takes risk assessment or the principle of risk as something that helps to manage and efficiently allocate the resources that the agency has. And in the classic, or in some classic treatments to the development of such frameworks, you have the elements of hazard identification. We want to know what the problem is. And then some other factors. I don't need to go through the list, but I think that we more or less know or this gives a certain idea about what risk regulation can look like or can include. And I would propose to take a broader view on risk regulation as a basis for the next statements that I'm going to make. We try to think about risk as an organizing principle for regulative and governance frameworks, and to help decision makers to create and formulate decision-making frameworks. But these players that use and apply risk-based approaches, they could be, well, the government, including administrative agencies, which is the classic application area. It could be also the regulated actors that deploy risk management methodologies in order to comply with legal obligations. To a lesser degree, until now, state legislators in lawmaking processes, they could also use risk-based methodologies and approaches to the problem. And maybe to a lesser degree, but not less important, the judiciary, when making judicial decisions, can look at the problem through the spectacles of risk and to see how risky is or not a certain consequence of a judiciary decision to protected interests that the law wants to secure. So all this was quite general, I assume, and maybe seems a little bit remote to the main topic of this Congress, data protection law. So let's talk about risks and the GDPR. So what is the relationship there? We know that the stated mission of the GDPR is, as explained in recital 75, it relates to the risks to the rights and freedoms of natural persons, and the regulation is mostly focusing, not only, but focusing on computerized processing of personal data. And if we screen the GDPR and look for the term risk, we see basically 4 categories of risks or processing. To be more precise, you have processing unlikely to result in a risk, processing that unlikely to result in a high risk, processing that likely to result in risk and likely to result in high risks. And all these categories are mentioned in different contexts in the GDPR itself, but there is no real system in the GDPR that tells us what these risks exactly are and how they should be classified. And in order to understand better what is called the risk-based approach in the GDPR, we need to look at other sources or other places and get a more integrative understanding of the idea of risk inside the GDPR. So when we look at the opinion of the Working Party 29, also adopted by the European Data Protection Board, they look at risk-based approaches from a relatively narrow perspective. So it is said to be a scalable and proportionate approach to compliance. So it's not really applicable across the board. It does not affect fundamental data protection principles. You can think about it as an internal process, maybe, of data processors, controllers, when they try to be compliant with certain obligations that they have, for example, in Articles 24, 25, 32, and 35 GDPR, where the obligation of the processor is in some way connected to the concept of risk. And it is in the literature and the theory, theoretical discussions, and I would say even dogmatic or doctrinal discussions, it's distinguished from a rights-based approach, the risk-based approach, as 2 different things. So this is the way many people look at the risk-based approach in data protection law until now. Fairly restricted application. We do not really look at the risks to the interests of natural persons or society when we think about the application and implementation of the risk-based approach. No influence on the substantive scope of rights and obligations, and there is a tension, as mentioned, with the rights-based approach that is supposed to be the majority view of the underlying principle of data protection law. And there is the principle of accountability and responsibility that could, in some way, smoothen the tension between rights-based approach and risk-based approach. This is a theoretical discussion. We'll see later in the presentation how this may be consolidated. And what I would like to offer is a different perspective about the risk-based approach in data protection law and also in the GDPR. So we can think about the risk-based approach or about the issue of risk as a symbiotic relationship between data protection as a legal instrument and risk as a regulatory principle, with various facets that can be combined together and enrich each other instead of standing in contrast to each other. So I propose to understand risk as an interpretation and application principle for data protection norms and instruments. And we can factor risks into certain concepts, interpretations, and processes of data protection law and compliance. And specifically today, I will talk in the remaining time about considering risks to be to the interest of data subjects as a relevant factor in the evaluation and conditions for a valid consent to the processing of personal data. All right, so now we try to zoom in on more familiar concepts and ideas from data protection law. We are familiar with consent as a legal basis for data processing, and we know that consent needs to be freely given, specific, informed, unambiguous, and revocable. The data protection experts among you know this already. There is a recent decision by the European Court of Justice talking about consent, explaining or reiterating basically our understanding of consent, in which the European Court of Justice said, among other things, that the data subjects need to receive enough information, so much information in such a form that they understand the consequences of that consent, and I might add also the negative consequences of that consent, meaning that the data subject is expected to create some sort of a risk analysis evaluation before they grant their consent, in the ideal case when all the circumstances are clear and served in an intelligible and accessible manner, clear and plain language, and so forth. And this is quite a high expectation that we have from data subjects considering the fact that we are asked to give our consent to data processing all the time, especially on the internet context. We need to know a lot of things. We need to process many things, and to basically reach a conclusion based on risk analysis that even risk professionals sometimes have hard times to achieve. We know the critique about consent. We know that a lot of scholars and practitioners say that consent doesn't really work in the way that the European Court of Justice expect the consent to work. There are structural, psychological issues that prevent from us to give informed consent in the sense of data protection law. And in the end, what happens is that consent turns into some sort of an automatism. We want to get somewhere, we want to get something over the internet, and we give our consent without really deliberating on the consequences of that decision that we make. The theoretical literature organizes the critique on consent in different ways. You have structural issues concerning the way websites, for example, or applications are representing the information, and you have cognitive issues that we all know. There is a rich, extensive literature about the problems with consent, basically arguing that consent doesn't really work many times. And in the end, what happens is that data subjects cannot or do not want to give that consent that data protection law would call valid or informed consent. So far, so good. I will talk very shortly about a theoretical topic. And the only thing I want to express here or to focus on is the nature, the legal nature of consent as a legal position. In order to explain this, I revert to an analysis, legal analysis or typology that was developed already a long time ago by a US scholar called Wesley Newcomb Hoffeld. And this scholar has proposed a certain way to examine, analyze legal situations. he took different URL positions and organized him in different ways. I'm not going to go into this theory in depth. What we need to understand is that these 8 URL relations supposedly can explain every complex situation between 2 parties. And I will focus on the right duty and power liability correlatives. This means that if somebody has the right to something, the other party in this pair of URL relations always has a duty. And if one party has a power, the other party in this examined URL relation has a liability. So if we go to a constellation of a right claim, we say that A holds a right claim. For example, A is a property owner. So A can exclude strangers from the property, and if B is a stranger, so A holds a right claim against B, and B holds a duty to respect the right and not to enter the property uninvited. But the same parties can also have a power and liability relationship, assuming that A, the property owner, gives permission to B to enter the property, so A has the power to change the legal position of himself and others and turn the duty not to enter the property into an immunity. So then B cannot be held liable for trespassing. Why do I say this? I say this because I want to present consent as a power held in the hand of the data subject. We sometimes think about consent in terms of rights or data subject right, or in this context, advocate for the power perspective. There are 3 basic arguments to look at consent as power. The first one is the typological explanation that I just highlighted. The type of legal position is a type of a power. If I give consent, I can change the legal position of myself and the data processor from a prohibition to process the data into a privilege to do that without having a negative legal consequences. There is a structural argument. Consent is not in the chapter in the GDPR that talks about the rights of the subject. It's in the part that talks about general principles. And there is a normative argument saying that, yeah, well, we want to empower data subjects to make decisions, to exercise their right of informational self-determination, as it is well known in Germany and also elsewhere. And all these reasons advocate for viewing consent as a legal power and not as a legal right. And the next step is to think about consent as a delegable power. So delegable meaning that I, as a legal subject, as a data subject, I do not always need to make the consent decision myself. I can empower somebody to exercise the power for me in certain circumstances. So legal powers are usually delegable, can give a power of attorney to somebody. There are power of appointment situations, agency situations, and all across the legal spectrum. We have exceptions that exist concerning rights that are especially important for human autonomy, dignity, and well-being. And the mainstream view in data protection law is that we talk about fundamental rights in the case of data protection. In principle, these fundamental rights are not alienable or dispensable. They cannot be, the rights, the personal fundamental rights and freedoms cannot be delegated or transferred to another party. So in the intermediate conclusion, which is the main view, basically consent should be exercised personally by the data subject after having conducted this risk analysis that the European Court of Justice expects data subjects to conduct. And the arguments for this mainstream view is public policy, substantive data protection perspective, and human rights perspective, and also textual interpretation of the GDPR when Article 6.1a says that the data subject has the right to give consent, or has given consent more accurately. And finally, there is the argumentum e contrario, saying that when the GDPR wanted to allow data subjects to delegate some of their capacity, so it did it explicitly. One example is Article 81 GDPR by the representation of data subject in case of disputes. The counter-arguments advocating for a delegable consent are summarized here. Basically, we're not talking about a right that is being transferred or delegated. We talk about a power, so no fundamental right is being waived, alienated, relinquished, abandoned, or compromised. The purpose of the consent instrument is actually to empower the data subject to make informed decisions. And when we come to the state that we cannot make these informed decisions alone, we want to call for help. We want somebody else to help us reach this decision, and we want to share this power that we have with a third party that will help us to make the best decisions for us. It happens all the time, all over the place, and it can also happen possibly in data protection law in the context of consent. It supports the idea of personal autonomy and the exercise of informational self-determination, And if we have the proper safeguards in place for the responsible delegation of consent power, this can benefit the owner of the holder of the personal right, the fundamental right, and not really harm the data subject. And we see this also in other, same idea in other legal grounds for the legalization, validation of data processing in Article 6.1f, for example. The legitimate interest of the controller sometimes can justify the data processing even without consent. So we have this balancing proportionality act playing a role in other legal bases for data processing. Why not in the context of consent? I jump to a related topic. I will do it very briefly in order to stay within my time limits. We talk about trusted data intermediaries recently in Europe and also elsewhere, and the possible roles that trusted data intermediaries can occupy in the data economy and the problems they can help us solving. One of the three main or major possible functions of trusted data intermediaries are highlighted here in bold letters: to facilitate consent management for users and controllers, to empower data subjects to control their data and draw benefits, and to enhance transparency, trust, legal certainty, and security. We hold trusted data intermediaries, at least the theory of their existence and application, high, and we think that they can help us solve many problems, including these ones, and including in the case of personal data. And those of you who are familiar with the Data Governance Act, they have noticed already this is not yet a law. This is a proposal by the European Commission, already in a very later stage of the trilogue process. We expect the Data Governance Act, the final text, to be announced later this year. But according to the draft that will be subject to some changes, we know that the Data Governance Act will create new types of data intermediaries, or define them and their roles and responsibilities. One type of intermediaries will be under current Article 1 91B. These are data intermediaries that basically take personal data and help the data subject to share it. And the second type is data altruism organizations that will take data from data subjects that want to donate maybe is a wrong term, but to share personal data for altruistic purposes, for public benefits, for public interest, and they will need somebody to manage the consent and the transfer of data for them. And the Data Governance Act lays down a detailed governance structure for these processes and the operation of these trusted data intermediaries, including notification, certification, depending on the type of the intermediary. And there is a very, I would say, seriously extensive list of monitoring conditions and transparency requirements. These bodies will be quite seriously regulated once this legislation passes. What do we know about the intersection between the Data Governance Act and the GDPR? So we have the no prejudice rule. The Data Governance Act should not affect the rights of data subjects under the GDPR, cannot derogate definitely from them. I argue that the Data Governance Act actually adds on top of the GDPR further safeguards and requirements laid upon the data intermediary, which is also in terms of data protection or the controller. And we know that there is prohibitions inside the DGA proposal that do not exist in the GDPR. So there is, for example, the obligation not to make any additional use of the data beyond intermediation. So the DGA tells the intermediary that it's not allowed to conduct any other business or have any other benefit other than intermediation services. We don't have a similar obligation in the GDPR. And we also have an obligation, and this is very important, in Article 1110 of the DGA draft, to act at the best interest of the data subject. We don't have any obligations like this in the GDPR. So the intermediary is actually acting as a fiduciary, having fiduciary obligations towards the data subject. And some argue, and I agree, that some provisions of the DGA that concern consent go even beyond the consent obligations under the GDPR, especially Article 22.3, which also says that the data subject can consent to the data processing operations in addition to consenting to the data processing purposes. This is something that we don't have in the GDPR. So I formulated 5 propositions about the connection between data intermediaries under the DGA and the GDPR requirements. From a risk-based perspective, the Data Governance Act provides a framework for risk management. We basically have controlled intermediaries that operate under a GDPR plus obligation. From a public policy perspective, there is no problem or no big concern if we appoint such controlled data risk managers as DGA controlled intermediaries to manage consents. Compliance with the DGA could, legally speaking, provide a rebuttable presumption that this specific intermediary is sufficiently secure for the rights that the data subject has protected under the GDPR as well. And the consolidation with all data protection principles is possible and warranted also in the case that the DGA requires or allows the delegation of consent to trusted data intermediaries. A quick example from recent legislation in Germany before I wrap up. Maybe some of you know that there is a new privacy law coming in Germany, will be implemented or enter into force in December this year. Is the telecommunication, telemedia data protection law. And it has two interesting provisions. One of them is Section 25, which is basically, the way it concerns cookies, it implements the e-privacy directive and some other European Court of Justice decisions into German law. And one of the things that it does, it requires consent for accessing data that is saved in the end device of the user, or for using all kinds of information that is retrieved from there. We need explicit consent. There are two exceptions that I'm going to talk about this, but the rule is consent according to the e-privacy guidelines, basically. And there is a novel acceptance of the consent management tool, PIMS, Privacy Information Management Systems, which are going to be vetted, certified organizations or tools for consent management tools. And these service providers, the law makes sure that the service providers are independent, impartial, secure, and reliable. This is regulated in subsection 2. And we still don't know exactly what this law will be regulate and how the consent management processes or protocols will work. The assumption is that the user is always in control on the conditions for the consent. The idea is basically to prevent cookie banners to jump all the time. If there is some sort of a profile that the PIMs are managing, so the browser already knows when the user will accept cookies and when not. So the management happens in the background, but it's quite clear, or it's assumed that the user is the one who basically decides on the conditions for granting consent. So the PIMs do not have a discretion to decide for the user about the consent. I come to the last slide, and this last slide basically summarizes my statements and ideas about the interaction between risk-based regulation, consent management, consent delegation, and the interaction with the Digital Governance Act. I realize that some of these ideas about consent and the possibility to delegate it are quite controversial, maybe would appear not very conservative in the eyes of data protection authorities and experts. I just bring it to the table for discussion, and I'm happy to receive feedback for these initial ideas. So thank you very much for listening.
Programımızın bugünkü bölümü sona ermiştir. İkinci oturumdaki konuşmacılarımıza ve oturum başkanımıza katkılarından dolayı teşekkür ediyoruz. Yarınki oturumumuz saat 9'da başlayacak olup toplamda 6 oturumdan oluşacaktır. Bugünkü programımızda emeği geçen herkese teşekkür ediyor, iyi akşamlar diliyoruz.